Good morning. My name is Anitra Jo, anak perempuan Joseph Leo, and my metric number is 01DAC24F2031. Today, I'll be presenting about the introduction of formation of a hire purchase. The case law involved is Lo Pingming versus MBF Finance PhD. In this case, Lo Pingming, the hirer, entered into a hire purchase agreement with MBF Finance PhD, the owner or financer, to obtain a certain good, which is a vehicle. Under the agreement, the goods were let out to the hirer for use, with the understanding that he would pay periodic installments over a fixed period. Once all installments were paid, the hirer had the option to purchase the goods, meaning that ownership would then be transferred to him. However, a dispute arose regarding the ownership of the goods before the final payment was made. The hirer claimed rights over the goods, but the owner, MBF Finance, maintained that legal ownership remained with them until the agreement was fully completed. The court held in favor of MBF Finance BHD and clarified the true legal nature of hire purchase agreement. Formation and nature of hire purchases agreement. A hire purchase agreement is a special type of contract where the owner lets goods out on hire and the hirer has the option to buy the goods after finishing all payments. The ownership stays with the owner until the final payment is made. According to Section 4, subsection 1 of the Act, before such an agreement is formed, the owner or dealer must provide a written statement that includes details of the goods and payment obligations, ensuring the hirer knows all terms beforehand. The booking fee and deposit can only be collected after specific forms are provided and signed. For the agreement to be valid, it must be in writing, signed by all parties, and probably completed. If these conditions are not met, the agreement is then void. Each item needs a separate hire purchase agreement unless they are sold as a set, and the owner must supply copies of the agreement and insurance documents within 14 days. In short, the formation of a hire purchase agreement follows strict legal steps to protect the hirer's rights and ensure transparency before both parties. That's all from me.
Greeting to Mr. Padiban sir. My name is Yashini Divya, daughter of Kartikeyan, and my metric number is 01DAC 24F2011. Today I am going to break down the highly detailed legal process into two core steps, that is disclosure and execution, and see what happens if they are missed. The first and most important step is mandatory disclosure. This is where the law makes sure the hirer knows exactly what they are getting into, both financially and contractually, before they sign anything. This pass actually involves two critical documents that must be served on the hirer. First, the financial summary, that is part 1. This document details the cost of the goods, the interest rate, the total amount payable, and the higher purchase price. This needs to be given to the hirer right at the start of negotiations. It is big picture price tag. Secondly is the full terms, that is part 2. After the financial summary, but still before the final contract is signed, the dealer must provide the hirer with full proposed contract terms. This is the complete legal document they are about to commit to. Crucially, the law states that the final hire purchase agreement cannot be entered into unless the hirer has been properly served with both of these statements. The penalty here is severe. If the owners fail to meet these disclosure requirements, the entire hire purchase agreement is considered void. Okay, once disclosure is complete, we move to the second phase, that is proper execution and delivery. This is where the paper trail is finalized. First, the execution itself has strict rules, that is, the hire purchase agreement must be in writing and it must be fully completed before the hirer puts pen to paper. It means the hirer signed the paper. It also needs to be signed by all parties, that is, the hirer, the owner, and any dealers. If you break this rule, For example, by having the hirer sign a blank form or by missing a signature, the contract is considered as void. Second, there is a requirement for delivery. After the contract is made, the owner has 14 days to serve the hirer with a copy of the signed agreement. They must also provide copies of any insurance policy or payment receipts if insurance was part of the deal. The penalty for failing to deliver these final copies is also serious. It makes the agreement unenforceable by the owner. This means the owner cannot legally enforce their rights under the contract, such as repossession. That's all from me. Thank you for seeing this video.
My name is Sri Mariamma, Doctor of JPSO. Number card matric is 01DAC24F2007. Today I want to talk about legal requirement. First is must be in writing. It is Hire Purchasing Act requires every agreement to be written, not variable. Written document protect both owner and hire by showing clear terms. Prevents misunderstanding about price repayment or goods. Act as legal evidence if any dispute areas. Second is must be signed by all parties. Signature is legal acceptance of duties and rights. Signed by owner, usually the finance company. Hire is a buyer. Dealer if involved as an intermediary. Agreement becomes effective only after signatures. All parties get a copy of the contract. That is, no blank or incomplete forms. All important details must be fulfilled before signing. Prevents is owner and dealers from acting unfair or hidden clause later. Protect the hire from fraud and extra charges. If signed blank, contract can be avoided. Fourth, requirement particular must be include the contract clear statement. When the contract is done, describe about the contract, its brand, model, condition, and then total charge plus interest so the higher no actual cost. Investment details, total number of investment, amount per investment, due date of each payment. Overall importance of the requirement is protects the right of the higher consumer, ensure fairness and transparency in repayment terms, prevent illegal practices and financial exploitation, creates a legal enforceable contract for both sides. Thank you.
Greetings to Sirpati. My name is Ramya, daughter of Ramachandran from class DAC 2. My metric card number is 01 DAC 24F 2021. Today I want to talk about post-contractual obligation. Post-contractual obligation is after contract signed, there's a few things that must be done and make it legal and fair. As for the first thing, the action of service with documents, which is um, which means the owner or the company must give the hirer the necessary paper, such as the owner must give a hirer completely copy and sign hire purchase agreement before done an agreement. This copy proved both lines they have signed a proper agreement. Thirdly, timeline. Timeline is the paper must be given within certain time. For example, few days after doing the contract. Doing it late could break the rules of the agreement. As for the final note, contract must be valid and legal. Two set of rules must be followed, such as law of rule and statutory rule. Common law of rule is offer acceptance and agreement. As for statutory rules, special laws that apply to hire purchase contract. That's all for me. Thank you.